Hello and welcome. Let's wait for everybody to get in that wants to be in. Here's some tunes.
There is a house in New Orleans. They call the rising sun. Hey, big, the rolling up in your boy. In God, I know I'm one. So my new jeans, my phone was the gambling man down in New Orleans. Now the only thing to gamble is a suitcase and the only time to be satisfied is when he's on drugs. Tell your children not to do what I have done. Spend your life in sin and misery in the house of the rising sun.
Alrighty, guys. I know you guys are probably hearing the fan. The good news is my other laptop came in today. So Drop is charging it up and I got to move everything. However, I've been going away from YouTube. I'm finding much better platforms that aren't so restrictive. But I found something that I think could be of importance. Maybe it is to you, maybe it's not, and that's okay. But let me bring some stuff up here. There's some reading, there's a little video. You know, I do what I do. Let me share the screen. And I see two people's here. That's okay. You know what? Other people might come back later. I'm never about the views, guys. You should know that. So, okay, so there's a case in front of the Supreme Court, and it's rather important, right? Well, I opened your door, and I did say I'm going live, so. But this case can actually make history. And last couple days, I've perusing around on some other sites. Rumble, I'm really enjoying Rumble. So this is the case. I'm going to play this video in a bit, right? So here's the actual filing in the court. So the title is, here the full backstory on the most consequential case in history, scheduled for a Supreme Court hearing. Could brothers from Ogden, Utah, have found a way to fix the 2020 vote thing, right? So it's the Brunson brothers, and oddly enough, they all play a trumpet and they go by the name of the trumpeters, right? Biblical, I don't know. So, why is the secret Brunson versus Adams lawsuit officially scheduled for a U.S. Supreme Court hearing being met with deafening silence from America's so-called media elite? The civil lawsuit was proactively hand-selected. Now, I don't know if you know it, guys, but the Supreme Court can get up to 8,000 cases a year. And you know what? Only 150, maybe 200 go before the Supreme Court. You know, there's only 5 of them. But anyway, by the U.S. Supreme Court in October of 2022, was written and filed by a band of brothers, an actual band of trumpet-playing brothers. They go by the name of the Trumpeters, without attorney representation, and seeks the most historic and consequential judicial remedy in America history. Why no coverage? Okay, so the video above, and I'm not going to play it right now. I'm going to read you some things first. Why questions that aren't being asked, but should be. The links below provide factual receipts available for all to see, including America's biased media. So I'm going to leave this link when I'm done under, in the description, like always. So, there's all this stuff. And the stuff I'm going to bring up is actually some of this. So, but let me go to, is it this one? I think it's this one. Okay, yeah, they might be a little mixed. So let me remove that. Oh, I didn't know. I just knocked and I didn't see you. So, here's the other. Okay, let's go here. Okay, so we'll go to citing history, and so this is a lot of the stuff that went down, right? So, and of course, it's not on main platforms. I don't know. Maybe I'll get whacked again on this one. Any event, this is NPR, the Capitol insurrection updates. Citing history, Senator Cruz wants a panel to probe elections. Right? So Republicans opposing Wednesday's electoral count have one proposal to deal with controversy. The Congress delay action for 10 days so an emergency electoral commission can audit the results and investigate voter fraud claims in the contested states. Senator Ted Cruz, Texas, cited public opinion polls about the fidelity of presidential election as a reason for the establishment of such a commission. So a commission was called for. They could have literally delayed everything for 10 days at least. I understand your concerns, but I urge you to pause and think, what does it say to the nearly half of country that believes the election was rigged if we don't even consider the claims of illegality and fraud? He told the Senate colleagues, many who have criticized his efforts. Cruz cited a 145-year-old precedent for such a panel. The 1876, presidential race between Rutherford B. Hayes and Samuel Tilden was also marred by allegations of widespread fraud. What is it? A stymied Congress decided to appoint an electoral commission with 5 House members, 5 senators, and 5 Supreme Court justices to investigate and resolve differences over the count. What I'm arguing for is Congress ought to do the same thing. We ought to have a fair inquiry, a fair audit into these results, and we ought to resolve these claims, not just dismiss them out of hand, he told Fox News host Maria Bartiromo, whatever her name is, on Sunday. But there are some crucial differences between the 1876 electoral controversy and today's election. In the former, Congress received a dueling slates of electors from 3 states, Louisiana, Florida, and South Carolina. That hasn't happened this time. Only one official slate of electors had been certified by each state, despite moves by some Republicans who send competing lists of names from several states. Also, unlike in 1876, the many fraud allegations in this year's elections have been repeatedly disproven through audits, recounts, state investigations, and in the courts. Judges, including some appointed by President Trump, have dismissed the allegations in dozens of cases. On a more practical level, it would be almost impossible for a newly formed independent commission to delve into so many allegations and reach some agreement on the facts in only 10 days. It took the 1876 commission weeks of contentious negotiations to reach a deal, which effectively ended Reconstruction. Even a staunch Trump supporter, such as Senator Lindsey Graham of South Carolina, has dismissed the latest commission proposal as little more than a stunt. Proposing a commission at this late date, which has zero chance of becoming reality, is not effectively fighting for President Trump, he tweeted Sunday. It appears to be more of a political dodge than an effective remedy. It also wouldn't be the first time Trump and his supporters called for a commission to investigate baseless claims of widespread voter fraud, and it didn't end well. The president appointed a bipartisan panel shortly after his 2016 election, in which he claimed between 3 million and 5 million people voted illegally. The commission was controversial from the start and only met twice before it was disbanded amid multiple lawsuits and complaints from state election directors about the panel demand for sensitive voter files. So here's the thing, guys, just type in your name and your address, and you don't have to go to the election board for voter files. You can see who your neighbor, your landlord voted for in the last election, right? During its 7 months of existence, the panel uncovered no evidence of widespread fraud. Okay, so there's more stories. Okay, let me get back here. Hi, Peggy. In any event, let's get rid of this. So here was just kind of like the base. And I heard there was over 100 senators and House members that had certain evidence or allegedly. And so they didn't hold it off. They did not have to do the swearing in on January 20th. They didn't. And so anyway, next on the hit list, let me see. Okay. Okay, well, another thing is the joint statement. What's this? Brunson brothers drain the swamp, right? Didn't we all hear that? The swamp is wide and deep. Brunson versus Alma S. Adams, ETAL. Biden, Harris, Pence, and 385 members of Congress. Currently, there are 2 lawsuits identical to each other. The first one, filed by Lloyd Bronson, is still held up in the Utah federal court. The second one, filed by Raylan J. Bronson, has made it to the Supreme Court of the United States. Docket number 22, let me outline this, 22380, where 9 justices in conference will vote. Only 4 needed to move to a hearing. So both lawsuits include defendant President Biden, Harris, former VP Pence, and 385 members of Congress for breaking their oath of office. See, this is not about a stolen election. This whole case, it's so simple. It's breaking their oath of office by voting against the proposition that came from members of Congress to investigate the claims that there were enemies of the Constitution who successfully rigged the election. Both lawsuits are about the defendants breaking their oath of office. I do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic. The question: how can you support and defend the Constitution against all enemies, foreign and domestic? Answer: you investigate. If there are claims that there is a threat, even if you don't believe there is a threat, you investigate. How else can you determine if there is a threat unless you investigate? You can't. Were there claims of a threat to the Constitution? Yes. Where did these serious claims come from? 100 members of Congress. What was the threat? That there were enemies of the Constitution who successfully rigged the 2020 election. Is this lawsuit about a rigged election? No. It's about the members of Congress who voted against the investigation, thereby thwarting the investigation. Was this a clear violation of the oath? Yes. The relief that Lloyd and Raylan are seeking, that defendants be permanently, watch this, right? Defendants be permanently removed from office and not allowed to hold a public office again. It means they can't even become the dog catcher, right? So the background: Lloyd, Rowland, Darren, and Gaynor Brunson, the brothers, witnessed the 2020 election along with claims from members of Congress that the election was rigged. What got their attention was when the proposition to investigate those claims was presented to Congress and put to vote. What came as a shock to the 4 brothers is when they discovered that 387 members of Congress, along with VP Mike Pence, actually voted against the proposed investigation, thus thwarting the investigation. Whether the election was rigged or not was no longer their main concern. What now became the concern was when those members of Congress violated their sworn oath by voting to thwart the investigation. The brothers wanted to do something about this. Their brother Darren had quite a lot of experience in the legal field, which started out when he became suing banks in an attempt to show the corruption in the part of the financial world. So he had enough knowledge to file a lawsuit against the now current 385 members. Don't forget these guys, okay? Yes, right? So that's where you get the 388. He already had experience with SCOTUS by bringing 2 petitions to them, both of which were denied, but this experience gave him enough success along the way to give him the confidence that maybe, just maybe, he might be able to do something about this thwarted investigation. Hey guys, I don't know if you can notice, but I can actually read. Drop got me new glasses, so I'm not struggling. I can read, I just couldn't see to read. The brother Gaynor was heavily occupied with his audio video television business, Rock Canyon Studios, so Darren got together with his other two brothers to plan out the strategy. They decided to have their oldest brother, Lloyd, to be the name on the lawsuit, which is called a complaint. And because he would be on the complaint, the court would refer to him as the plaintiff. The 388 people being sued will now be called defendants. Lloyd filed the complaints, which eventually got stuck in the federal court. So they got together and decided to have their brother Roland file the identical lawsuit with his name on it. In Utah, 2nd District Court, while Lloyd's lawsuit continued to be held hostage in the federal court. Rollins' lawsuit eventually made it to the SCOTUS. Here are the events of both lawsuits. Guys, this looks a little long, but Lloyd files the complaint. The brothers make changes. Lloyd files the First Amendment complaint. March 31st, the clerk of court had the U.S. Marshals serve the First Amendment complaint on 85 defendants, including Pelosi and Maxine Waters, before being stopped by the court, claiming it was a clerical order by the deputy clerk. So in June, here was Rollin, and they take a copy of Louis' first. I'm pretty sure that the video that I'm going to show all this, but there's motions to dismiss. This is how long that the court systems go. And y'all can, I'll leave the links so you can read it for yourself. And this is all this. I could probably also find the actual filings. Wow, look at all this, right? In any event, July 6, 2022, the brothers prepare the opposition to the attorney's attempt to dismiss the lawsuit, and Lloyd files it in a Utah federal court. The brothers are still waiting to this day for the court to make a decision. But we don't need to follow Lloyd because he's hung up. This is the important date, November 30th, 2022. SCOTUS set the conference date for Jan 6, 2023. The 9 justices will meet January 6. Isn't that a magic date? To discuss the case and decide by vote if they want to move it to a hearing, where they will officially judge the case and decide by vote if defendants should be removed from office. We're talking about, guys, this is huge, right? We're talking about the whole Congress. The president, the vice president. Oh. So, it just took a couple trumpet players. Hi, Disciple. Hi, G-Day. Hi, Trinidad. Hi, guys. So, these 4 brothers from Utah. Okay, the way to go about this wasn't about bad machines. It wasn't about bad programming. It didn't even come down to people testifying and signing their name that if they were lying, they would go to jail. It came down to violating the oath, right? The oath of office. So, my hat's off to the Brunson brothers. And they got a small little clip for the background. And I'm going to play that for you guys. I know my computer's making a clankety sound. And through Grumpy Monkey, right? Oh, and by the way, I got a .com. It'll be set up hopefully this weekend. So you'll be able to find grumpymonkeyssoap.com. I found out that Etsy was one of those Green New Deal companies, right? So they're charging me out the wazoo. They're charging me 6.5% of the shipping, and they don't even touch the shipping. I got listing. Oh, any event, Drop is setting me up the .com. That's besides the point. I'll be soaping tomorrow. But let me play this little video, and I will. You know, guys, I'm really good. Maybe the description's not there right now, but I saw this and I really, really thought, this is something you really are not seeing or hearing. I'm not even seeing it on YouTube. You know, I might be put in the bad girls corner again. Let me see, which one was it. Okay, I think this is it.
Good evening. This is Rob Cunningham with my special guest, Bill Quinn, tonight. We are going to bring you a fascinating discussion of a Supreme Court case involving four brothers from Utah. We want to talk very briefly about the case itself, but then we're going to dig deeply into the why. Why is this case so unique? Why is it profound? We really want you to stay with us. This is going to maybe be a 20-minute video. You're going to learn things here that I'm pretty sure you won't hear anywhere else. But Bill, good evening.
Hey, good evening. Thank you for getting us together, Rob.
Well, it's my pleasure. Bill, do me a favor, just give the audience a quick primer on you and your background and what gives you some experience and credibility on this topic.
Well, thank you. So, it's kind of funny. These last 2 years, a lot of time's been spent on election integrity and trying to find out what is causing these strange moves by government and so forth. I spent the previous 25, almost 30 years in various leadership positions in technology and software and hardware. And my family has been involved in a number of different things going back through time. I am lucky enough to have a family that dates itself all the way back to the War of Independence. So I feel a personal responsibility to dig deeper into these things and try to come up with some truths as we go forward.
Awesome. Well, Bill, let's kick it off. I'm going to share the screen here so that everyone can sort of see, follow along with us. We've got just a few slides, but I think it's going to help everybody follow with us as far as, let's see, let me get to the very first. Here we go. All right. I'm going to let you take it from here, Bill.
Okay. So the case we're discussing is Brunson versus Adams. And it surfaced almost quietly about 3.5 weeks ago and was posted in summary on Truth Social and a little bit on Twitter and so forth. As you learn more about the case, it becomes more and more fascinating. So as Rob said, it began with work by several brothers out in Ogden, Utah. And they, after the 2020 election, they could tell that there was something really wrong that had happened. And so they determined they were going to spend their time looking at what might have happened here and how do we go pursue this in a legal manner. So what's interesting about the case is, unlike most of the cases you and most of our listeners have heard about since the 2020 election, it doesn't attempt to prove fraud. What it talks about is that Congress heard about and was given valid concerns following the 2020 election that should have resulted in a pause and a chance to investigate what was causing all these concerns. If you recall, on January 6th, Congress was asked to either certify or dig deeper into the objections of senators, legislators, and others that had brought these concerns forward. And Congress voted not to pause and not to investigate the claims. By so doing, this case asserts that they violated their oath and, in fact, went contrary to the Constitution. It asks that the defendants should be immediately removed from office and barred from holding office in the future.
Now, Bill, let me jump in for a second, because I understand it's important for the audience to know this is a civil case.
That's correct.
It is not a criminal case. These plaintiffs are not asking now to back up a little bit more, to not investigate what amounts to an act of war. Evidence of officially notified evidence that election interference that could possibly put a politician in office that's beholden to or under the influence of a foreign entity is indeed an attack on our national infrastructure. It's an attack on our political system, and it is considered an act of war. And after being notified, everybody goes, nah, 10 days, we're in a hurry, we need to get this done, forget about it. Given that background, to have a civil complaint that's only asking for no criminal prosecution, no financial fine, no jail time, all these plaintiffs are asking for is, A, did they break the law, which clearly they did, and B, should they lose the right to ever hold public office again? That's it, correct?
It is. That's what this case asks for. If you look at other, I'll call it similar cases at a lower level in the past, there have been cases whereby by filing a civil suit, depending on the findings of that suit, there could be in separate action criminal charges filed, but it doesn't ask for those because it is, as you state, a civil case.
And so the Supreme Court has this in its docket. We're going to go there now, but it's sitting there, and look at, tell us about who they're claiming looked the other way and ignored notification of a potential act of war against the United States.
It includes as defendants Pence, Biden, Harris, Pelosi, and 385 other members of Congress. So essentially everybody that chose to ignore the concerns, fail to investigate, and simply proceeded on certifying the electors as if nothing was wrong. So what's interesting is two things here. One is where did this even thought of pause come from? Well, if you recall, on just before the certification vote on January 6th, I believe it was January 2nd and 3rd, there was a letter and a statement put forth by Ted Cruz, and several other senators, and very frankly, several other legislators and others, saying they really asked Congress directly, please take the time to dig into this. So there was a discrete question, a discrete request of Congress to look into this. Most people thought at the time, well, isn't this unique? But in fact, it's happened in the past. If you look back to the Hayes-Tilden race back in 1877, the same thing happened. People came forward, they asked Congress for a 10-day pause. And in that case, Congress did, in fact, pause the certification and look deeply into what had happened. So this is not without precedent.
Bill, let me take a point of personal privilege here, and I don't want to go off on a tangent, but I do want to I want to put a marker on the ground here. I don't know why they wouldn't have taken a look at this. When there's legal precedent, there is constitutional requirement. It's prudent. If they would have done it 10 days, it would have taken them out to the, let's say the 17th of January. It would not, if they didn't find anything, it certainly would not have slowed the January 21st inauguration. It wouldn't have delayed anything. They would have just taken, it would have been an insurance policy and given the American public assurance that, hey, we looked into it. There's nothing here. There's no evidence. But I want to add a caveat. There is empirical evidence that there were at least 8 FBI confidential informants that had been working with the FBI for at least 12 months prior to the January 6th certification date. Yep. On being in Washington, D.C. Trained, staffed, positioned FBI confidential agents inside of the folks that gathered for the Trump rally on certification day. And twice, we've had a minimum of twice, we've had an FBI director perjure himself before Congress, say he knew nothing about it. He had no idea that there would be any FBI involvement in the quote unquote insurrection. It seems as if everything was staged, planned, and January 6th was an immovable date based on an agenda, and possibly, I'm just conjecturing, I have no evidence, but possibly they didn't want to take a look at this. They didn't want to spend the 10 days because they had alternate plans already set up for January the 6th that they couldn't move.
Yeah, it is very fascinating. Add to that something that should have been discovered prior to January 6th, but was discussed just after. So if you recall, the presidential executive order 13848 requires that an investigation be done following an election, and that the Director of National Intelligence issue a report within 45 days of that election saying, did we find any foreign interference or any evidence of foreign interference? If you recall, when 43 days after the election to come up is the second week of December, DNI Ratcliffe came forward and said, I'm sorry, I'm not going to be on time because I've been unable to get the 17 intelligence agencies to come forward with their reports. So I won't be able to produce my report yet. What is fascinating now in retrospect, thinking of Senator Cruz's request and the request that was in fact ignored by Congress, is on the 19th of January, the day before the inauguration, DNI Ratcliffe came forward and in fact said, we did find evidence of foreign interference in the 2020 election. We can't agree and understand just how it may have affected the election, but they admitted evidence. So when you add that into the request that was in front of Congress, the fact that they decided to take no action is even more concerning.
Well, and before we get to the next slide, which is really going to be the meat of this, because we talked about the who, what, when, how, why, the facts of this case. Now we're going to get into some interesting questions, but you just triggered in my mind, Bill. We have to realize this, as we're shooting this video, we have Elon Musk showing basically what amounts to ballot stuffing on behalf of the Democratic National Committee and Twitter partnering to censor news and block information in the 2020 election. And today we have a 1,000+ page document that is an extensive document released from dozens of FBI whistleblowers to the House that is delineating how infested and rotten to the core and politicized the DOJ and the FBI are, how they have been operating for years as an extension of the Democratic Party. And all of this information the information from money laundering in Ukraine and to the Democratic Party to the election. Now we've got the Twitter information coming out, and all the DMs are about to leak out this week between all the different operatives on Capitol Hill working in collusion to restrict the First Amendment rights of Americans to speak freely on behalf of one party. And then we've got this 1,000-page plus document with insiders, people that work at the FBI and the DOJ. These aren't just rumors or reporters. These are firsthand eyewitnesses, federal employee whistleblowers that have provided the House with enough to fill over 1,000 pages of evidence and testimony. So the context for the Brunson case being before the Supreme Court with all of this mountain of evidence, just like a tsunami, it's just washing over America just in the last 7 days. I find this case fascinating. So, let's go to these fascinating questions, and go ahead, take the first one.
Okay, so the first question is, this case came up quietly, I'll call it somewhat quickly, to the Supreme Court. Often it takes years for a case to reach the Supreme Court. This was actually one of several cases filed by the brothers, but it made it through the gauntlet, coming from state court to then federal court, and then ultimately reaching the Supreme Court. And the Supreme Court chooses the cases that they elect to hear. It isn't commonly known. There's somewhere between 4,000 and 7,000 cases submitted for the Supreme Court's consideration each year. They only choose a couple, 300. And so one question that stands out to me is, why would they choose this case? Why is this even on the radar? They have to know that by bringing this onto their docket, it's going to receive national publicity. Why would they do that? It is very, very interesting. And in fact, one of the brothers that's been interviewed elsewhere talks about the fact that they were actually contacted by the clerk of the Supreme Court and asked to, one, when can you submit the case? And two, can you add a few things that we would like to have in your filing as it comes in? And so the very fact that proactively, one of the clerks from the Supreme Court reached back out to the brothers and asked for additional information, I find fascinating.
Well, and in context to that, Bill, what's also fascinating is because this isn't a court case that's been adjudicated, it's not under appeal, because this hasn't gone to trial, and the Supreme Court reached in and took it under an emergency provision of our Constitution and the Supreme Court statutes. It's got special classification under emergency status, which means the Supreme Court can look at the evidence, they can convene, they can render a verdict, and they can adjudicate the justice or the punishment like that at any time they feel like it, with no notice. Like this is an earth-shattering event. I've read in some places that this is perhaps the most power ever handed to the Supreme Court of the United States since it was formed.
Well,
it's that important, because theoretically they could meet at 8 o'clock in the morning, and by noon 387 people don't have a job that are elected members of the House and the Senate, and the president and the vice president.
That's true. To be clear for our viewers, I mean, they could choose anything at this stage. Correct. They can choose to continue it. They can choose to hear more about it. They can, we'll talk about the exact status that it's at now, but they can have all the choices available to them. So it is impossible to predict exactly what's going to happen or when. But the very fact that it's in front of them, to me, is a message.
Well, and one last thing, not to jump in too much here, but some research, and again, what I'm about to say is speculation, not verified. I'm not claiming it to be true. What I'm saying is through research and through understanding, you always want to follow the motive. We're asking questions. So the question would be, why? Why this case? Why now? Why in the middle of a lame duck Congress? Lame duck Congresses are probably the singular most dangerous points in time for we the people as citizens, for Congress to do nefarious acts that are in their best interest, not ours. They can make a quick decision with no accountability, especially if they're not coming back to office. They have between now and the new Congress is sworn in on January the 3rd. So they want to have a little final payday, a little money put in a trust fund offshore, or they want to get that first job at a Wall Street firm. All they got to do is vote a specific way, and boom, you know what? You don't have to worry about getting reelected, but we really would use your support, you know, to understand how much nefariousness can happen in a lame duck Congress. On Christmas Eve, 1913, when everyone had gone home, they ran through the Federal Reserve Act and gave us the U.S. Federal Reserve, complete with an income tax and an IRS. So they're capable of doing anything. And the rumors are out on the street that a couple of possibilities: this Congress would love to pack the Supreme Court. They would love to try to slip through a bill. Now they have a 51 vote majority with the vice president being the tiebreaker. That if they could get 51 votes, they could increase the Supreme Court to 15 members instead of 9. Mm-hmm. If they did that, all of a sudden they need 6 new appointees. And guess who gets to make those appointments? And guess who gets to confirm them? And in the event they did that, they could then have a super majority in the Supreme Court, and they could do things like, federalize Roe v. Wade, make that whole verdict that just was passed irrelevant. Even if they don't pack the court, the other option is that they might try to somehow or another put a late night, dark of the night when nobody's looking rider on a bill and federalize abortion, which is basically the same thing, to make abortion a right at the federal level, and it would supersede the states' rights to make any decisions about Roe v. Wade. So there are some potential plausible reasons why, out of self-defense, to preserve their relevance among the 3 branches of government, that the Supreme Court went and got a case like this, because it's like giving them a loaded gun. Now they can play hardball. If they're going to try to, if the Congress, this lame duck Congress, is going to try to pack the court or reverse their Roe v. Wade decision, they might not want to do that while the Congress can just, the Supreme Court, if I'm badly mistaken, it only takes 4 out of the 9 justices to adjudicate this case. Is that correct?
It would take 4 at the current stage, where it's currently in set for private conference. It will take 4 justices to move it to the next phase, which typically would be a full hearing. Beyond that, I believe we get into looking at a majority of the board, the majority of the bar, that level.
Okay.
So one other interesting thing that happened, by the way, in the middle of the case, and just before Thanksgiving, when the court takes on a case like this, they give both parties the chance to be heard. And in this case, they set November 23rd as the date by which the defendants needed to, if they wished to, provide a written response to the assertions of the case. Instead of what normally would happen, the U.S. Solicitor General, Elizabeth Prelogar, had put herself in the place of the defendants' attorneys. So the defendants' attorneys were removed, and Elizabeth Prelogar took that position in the case and filed a waiver of response to this case. That does 2 things. One, it provides no answer from the defendants as to the validity or their dispute of the case, and allows the court to proceed. So, as I mentioned a minute ago, at this stage, it's now been set. Copies of all the case documents have been given to each one of the justices, and they are set currently on the docket to review the case in private conference on, believe it or not, January 6th, 2023. So once again, you look back at the unbelievable steps that this has gone through, and the sort of interesting we'll call them for this setting a coincidence in terms of dates. I find it once again very, very interesting and quite unexpected.
And to your point, Bill, whether it's the date that this thing actually happens or not, the fact that they picked January the 6th to hear this date is, if nothing else, a calm. It's also a coincidence. But it's also true, I believe, that nothing limits or restricts. If they decide to wake up tomorrow after a cup of coffee and some orange juice to hear this, to vote on this tomorrow and hear it tomorrow afternoon, they have unlimited ability to hear and or then convene and or rule on this case whenever they feel like it. There is no law or ordinance or policy or regulation that says once you pick a date, it's got to be that date. They have total flexibility, correct?
As far as I can determine, that's true. They have all options are available to them. They can reprioritize the case. They could delve deeper into it. They can have other steps taken surrounding the case. In the meantime, they can recalendar it. Everything's wide open. They can choose to do anything. Think about it. There is no higher court in the land. Consequently, they get to choose what they do with it at this point. So,
and Bill, the fascinating thing, let's put a little bit more unbelievable context on this. There's not a single lawyer on the plaintiff's side involved in this. This is 4 brothers. None of them have a law degree. None of them have been to law school. They're self-studied. They're representative of a perfect representation of we the people, who were focused, who saw a need, who went about trying to right a wrong. They put this together on their own accord with their own research, with an incredible investment of time, but they're navigating from Ogden, Utah to the Supreme Court without an attorney.
that's true. Actually, you mentioned there were brothers collaborating. They are collaborating. In fact, in this case, only one of the brothers' name is actually on this case. It's Roland Brunson. So he's backed up by his family. But at the end of the day, it's notable and very, very unusual that Supreme Court would allow a case that is in fact pro se, meaning a plaintiff that is not an attorney pleading the case or presenting the case on his own.
Well, and the uniqueness of the fact that there's only one brother on this case is because 3 of the brothers filed in 3 different strategies, knowing that it might get hung up in one path versus the other. They didn't want to have a single point of failure, so they went down 3 roads, and whichever one made it through the Supreme Court, they were happy with it, correct?
That's right. And one is still hung up at a lower level. So
Right.
It didn't make the cut, and Roland's case has.
It showed brilliance on their part. They really understand the process, the procedure, and the law, and they did this again without a law degree.
Fascinating. And it's really, really interesting.
So tell us a little bit about the status, and then again, what could happen next.
So again, this has now been distributed to each of the justices. It's set on calendared on the docket for private conference on January 6th. They could again move it up. They may be taking action on it for all we know. They might be looking at various facts surrounding the case or other things. Even now, we don't know. But more importantly, it is calendared and due to go to the next level, as we can see from this. And folks can go and look for themselves on the Supreme Court docket, which is available to the public. Simply look up Brunson, and you'll find the case listing and be able to see the change in status at any time that they wish.
All public information. It's all out there on the record. This isn't anything that's hidden or made up. It's not a conspiracy theory. This is all a matter for public record. Anybody can go look at this.
That's exactly right. Along with all the data regarding the claims that were filed and concerns that were presented by Ted Cruz and the rest of the senators, and the history, very frankly, around the 1876 election and what happened then. So again, this kind of goes back to, the basis of it seems and is spoken of in such a simple manner. I mean, rather than trying to prove the complexities of fraud and so forth, this goes straight to, did these people violate their oath? Did they violate the Constitution? And to your point a few minutes ago, all it asks for is a civil remedy. One of the other capabilities that the Supreme Court would have would be to refer it if they find that, in fact, oaths have been broken and perhaps the Constitution has been circumvened. They can refer it for other action to other authorities. And as you said, take nearly immediate action should they so choose.
Right. And the key thing about that bill is they took immediate action. They ruled at 12 o'clock. At 12:05, they're going to have a box and a Secret Service agent, the sergeant at arms. They're going to be taking their pens and their koozies and their cups and their family photos, and they're going to be walked out of their office, and they're not even going to get the courtesy of a military flight home. I mean, they're going to be walked off. They will not be, from that second there's a ruling, they cannot cast a vote. They have no standing. They are out of office, and they can never hold public office again if it were to be ruled in the fact that it'd be kindly to say that they were just negligent in their duties. If it was referred to a criminal case and they knowingly did it, or they looked the other way, we're talking about a potential foreign influence Manchurian administration governing the United States of America, endangering 340 million U.S. citizens, otherwise known as treason and sedition. So theoretically, these elected officers that they're bound to the sworn oath that they took. It's not optional. It's not non-negotiable. They said they shall defend the Constitution against all enemies, foreign and domestic. And if they did not, it could easily be they could be transferred out, and then in a different court, more justice could be administered other than just a civil, penalty.
Yeah, it would. If they were to have that finding in the case, they could act broadly to remove folks from office and take other steps that they deemed appropriate under the circumstances. So certainly can't count on that yet.
We're not counting on it, but it's fascinating
but just to have it sitting there as a possibility is remarkable.
Well, this next slide's going to be fun. It's going to be extremely fun because we've been serious. We've been talking about heavy subjects. We've been talking about a legal case, a Supreme Court case, an election in 2020, massive potential, anywhere from a nothing burger all the way up to historic in every regard, that nothing like we've ever seen in the history of the United States, somewhere in between. 4 brothers, none of them are lawyers. They're all 4 musicians. They formed a band when they were in high school in 1971. And how ironic is it? 4 brothers from Utah formed a band, and they're all 4 trumpet players. It's a trumpet band of brothers that began their band career the very year the U.S. Federal Reserve went off the gold standard in 1971, and they're blowing silver trumpets as a band of brothers. So tell me a little bit about them, Bill.
Well, it's very interesting. Their father was actually a trumpet player as well. And so they learned at a very early age that the joys of brass music. They've appeared on a number of different venues. I haven't heard how often they're doing things currently, but it is it's just another one of these amazing circumstances. Here we are with the leader of the free world, fighting like crazy, trying to get justice from the 2020 election. And they just happen to be trumpet players all, and have appeared on a number of different shows. Going back some number of years, I think we had talked earlier, they were on the Johnny Carson show and others. And it's just one of those circumstances you can't explain, but boy, is it interesting.
You can't make it up. They've been in the White House. They've been the Rose Bowl parade. They've been Nashville. They've been, like you said, at Johnny Carson show. there's a video out there that's about 24, 25 minutes long or something. It's just a video montage of all the different things. And these guys are apparently remarkably talented and respected across the music industry as some of the absolute finest trumpet players that have come out of America. So, you got four brothers that are not lawyers from Ogden, Utah, fighting, one of the most significant elections in history with a case before the Supreme Court. And we've got 27 days between now and the lame duck session is over. You can't make this stuff up, Bill.
We've all heard and many have prayed for movement on these issues, and so here we begin to see what might be the beginnings of some movement. At the very least, we've talked about the possibilities of the case, but at the very least, in my mind, one of the things this is doing is getting people aware. Again, regardless right now of the outcome, they're getting people all across the country and around the world aware of what was done, what was neglected that should have been done, and who did it. I mean, who made what choices, and now the question becomes why. As you said earlier, it's what was the motivation to jump over, an investigation? What was so important that this had to be approved and the vote certified on the 6th? Especially now when you think about, wait a minute, what were they planning and how long were they planning it surrounding January 6th? So I suspect the coming very few weeks will hold some interesting information at the very least, and perhaps, as you say, some historical things that we'll be able to see and be a part of.
Amen. Amen. Hey, if nothing else, America, whether we like it or not, is getting one of the greatest educations in civics and history and political science and government and law. We're seeing what
healthcare,
what people are capable of doing. Never say one person can't make a difference. Here's a trumpet player that's got a case before the Supreme Court that could topple the government of the most powerful nation in the world. One person without a law degree. So look, this whole story, it's life is stranger than fiction. You can't make this stuff up. As William Shakespeare said, all the world's a stage. These guys, however, are not stage actors. These are just patriotic, hardworking, down to earth, brothers that love this country, and they want to make a difference, and they are. It's inspiring at an absolute minimum.
You bet. You can see it. You can see it when you look at this in other pictures. You can see it in their faces. These guys are having a good time. Now, this happens to be a pretty long ago picture, but Loy has appeared on a number of different podcasts in the last two or 2.5 weeks, and you can feel and see the excitement in each one of them. Yeah. Well, Bill, thank you so much. I think we probably went over the 20 minutes here just a little bit, but this is a topic everyone ought to listen to. I want to mention that you and I co-wrote an article last week on cdm.press. We wrote about this article. We'll link to it below this video as well. But that article's gotten almost close to 30,000 views. And that was a week ago. In the context of this case, was an eternity ago, because this just broke out on the scene. It's obviously getting zero coverage in the mainstream media. We can't even find some conservative folks won't even talk about it or give it any coverage. But this is an atomic bomb that everyone seems to be ignoring in at least the typical news channels. We thought this was there's smoke here, and usually where there's smoke, there's fire. As more happens, I'm sure we'll have the opportunity to bring it out so people can understand it and understand the context. So looking forward to that in the coming days and weeks. Bill, thank you so much. Have a great night.
All right, guys. So that was quite interesting. Let me move that. There's a Rumble thing. I don't know how long it is, but it has I don't know if I want to go there. Okay, let's oh, I don't know how long it is. It could be. I haven't actually watched it, so it could be like catch soup, catch what you can. It takes a minute to load. It is. It's 46 minutes. So let's see.
Good afternoon, friends. Ashley at W.
All right. So why the heck not, right? Yes, disciple, you are correct. But like I said, definitely drop a wheezes all around. So when you get a hold of me, if he doesn't get a hold of you in the chat room, oh, there he is. Gee, asking you shall receive. Oh, I'm sorry, Drop. Disciple was asking if I knew anything about trusts. Let me see. Trusts and equity. And I said that possibly you might know. That's not my forte, right? So I know that you did some filing for courts and whatnot. So you might be someone better for him to ask. But okay, so let's just let's make a little time of it. So we'll just go to Rumble, because they got some news. It's all about the court case 22-380. So let's hit play.
Good afternoon, friends. Ashley at WAT News. It is November the 18th, 2022, and some of my listeners had been messaging me about this Supreme Court case that had just come to people's attention recently that was, I believe, filed in October of 2022. It's Supreme Court case number 22-380. Again, 22-380, and I'm on the supremecourt.gov site. This case is titled Raylan J. Brunson, Petitioner vs. Alma S. Adams et al. Docketed October the 24th, 2022. Lower Court, United States Court of Appeals for the 10th Circuit. Case number is 22-4007. Decision date October the 6th, 2022. So this was filed October the 20th. It's a petition for a writ of certiorari. So I looked that up. A writ of certiorari is a type of writ meant for rare use by which an appellate court decides to review a case at its discretion. The word certiorari comes from law Latin, means to be more fully informed. A writ of certiorari orders a lower court to deliver its record in a case so that the higher court may review it. The U.S. Supreme Court uses certiorari to select most of the cases it hears. The writ of certiorari is a common law writ which may be abrogated or controlled entirely by statute or court rules. So that was from Legal Information Institute, LII. So now when I look more into the case, I'm on casetext.com, which gives me sort of a background of the Brunson vs. Adams case, right, which is what we're talking about here. Raylan J. Brunson vs. Alma S. Adams et al. Defendants. They're both the defendants. And first, I guess what the United States government or different people, right? There's a lot of defendants in this case. Report and recommendation. Jarrett C. Bennett, United States Magistrate Judge. District Judge Jill N. Parrish referred this case to Magistrate Judge Jarrett C. Bennett under 28 U.S.C. Section 636B1B before the court is plaintiff Raylan J. Brunson. Mr. Brunson's motion to remand for the following reasons. The court respectfully recommends that Mr. Brunson's motion to remand be denied. So we have a background here. Mr. Brunson, appearing pro se, challenges the removal of his case to federal court. Mr. Brunson commenced this action on June the 21st, 2021, in the 2nd District Court of the State of Utah against 129 members of the United States House of Representatives, 94 United States Senators, President Biden, Vice President Harris, and former Vice President Pence collectively won the defendants. In general terms, Mr. Brunson's complaint seeks redress for the violation of his constitutional protected right to participate in an honest and fair election. Right? So in a sense, this person is suing 129 members of the United States House of Representatives, 94 senators, United States senators, which is almost all of them, except what, 6? Right? There's 100. He's also suing President Biden, Vice President Harris, and former VP Pence. Right? So they're all the defendants. So there's 100 and 200 and a lot of people as the defendants in this, right? Mr. Brunson's claims are based on inter alia, the United States Constitution, and defendants' sworn oaths of office to, quote, support and defend the Constitution of the United States against all enemies, foreign and domestic. Yeah, you didn't do your job, right? You allowed some people to come in and rig this thing, and you sat back and let it go down, right? Of course, that's not in the Supreme Court legalese jargon the way I'm speaking. Right? You wouldn't say, and you let that shit go down, but you know what I'm talking about. Mr. Brunson alleges that defendants violated the Constitution and their respective oaths by intentionally refusing to ensure an honest and fair election. Right? You intentionally rigged the election result, right? You didn't allow it to be a fair election. Additionally, and more specifically, Mr. Brunson asserts that members of Congress are obligated to, quote, reject electoral college vote submissions from states whose electoral systems are so badly flawed as to render their vote submissions unreliable, untrustworthy, and unworthy of acceptance, unquote. Mr. Brunson claims that despite this obligation, during the January 6, 2021 proceedings to count electoral college votes, defendants, quote, knowingly mocked their oaths and became, quote, enemies of the U.S. Constitution they swore to protect, unquote, by, quote, allowing fraudulent votes to be counted. According to Mr. Brunson, the 2020 presidential election was, quote, rigged in every single state, unquote. And despite evidence of voter and election fraud, defendants, quote, intentionally refused to investigate the evidence and conspired to cover up the evidence, unquote. Mr. Brunson argues that the two defendants' conduct constituted an attack against the U.S. Constitution, quote unquote, that resulted in the fraudulent inauguration of President Biden and VP Harris. Mr. Brunson's requested relief includes, among other things, the immediate removal of defendants from office, an order that former President Trump immediately be allowed to be inaugurated president, unquote, and money damages in the amount of $2,905 billion. So that's a huge amount of money. I don't think it's 2.95 billion. I think it's 2,905 billion, which could be a massive number. Excuse me. On August the 5th, 2021, the U.S. Attorney for the District of Utah, as counsel for defendants, filed a notice of removal in this court. The notice relies on 28 U.S.C. Section 1442A1 and 1442A4, which authorized the removal of a civil action commenced in a state court against, quote, a New York officer, any officer of the United States for or relating to any act under color of such office, unquote. On August the 9th, 2020, Mr. Brunson filed a motion to remand the action to state court. Mr. Brunson argues that remand is required because, one, his claims do not depend on federal law, and under the well-pleaded complaint rule, federal defenses do not provide a basis for removal, and two, the federal court is biased against him. As explained in detail below, defendants' removal of this state court action under 28 U.S.C. Section 1442A was proper. Discussion. Section 1442, commonly referred to as, quote, federal officer removal statute, unquote, authorizes the removal to federal court of any civil action or criminal prosecution commenced in a state court against any officer or any person acting under that officer of the United States or of any agency thereof in an official or individual capacity for or relating to any act under color of such office. Section 1442A is an exception to the well-pleaded complaint rule, allowing for the removal of a civil action commenced in the state court regardless of whether a federal question appears on the face of the complaint. The intended purpose of Section 1442A is to protect the government from having to litigate immunity defenses, quote unquote, in hostile state courts, quote unquote. Therefore, unlike the general removal statute, i.e. 28 U.S.C. Section 1441, which must be strictly construed in favor of remand, Section 1442A is liberally construed in favor of granting federal officers and members of Congress access to a federal forum to litigate the merits of defenses arising from their official duties. Indeed, the United States Supreme Court has cautioned that the liberal policy in favor of federal officer removal should not be frustrated by a narrow, grudging interpretation. So they're talking about removing people from office who've done this, right? You've allowed an illegal election to go on. You've allowed the election to be stolen by various ways of cheating, right? You knew that this was going on. You did nothing to stop it, right? Which is a dereliction of your duty of your sworn oath that you take to fight against all enemies, domestic and foreign, right? You didn't protect your country's election results. And in fact, you purposely rigged them in favor of one side, and you knowingly went ahead with that instead of doing your best to stop it. To establish removal under Section 1442A, defendant must show 1, that the defendant is a federal officer, 2, that the charged conduct was carried out for or in relation to the defendant's asserted official authority, and 3, that the defendant has a colorable federal offense, quote unquote. The Supreme Court has clarified that if a defendant meets these requirements, the, quote, right of removal is absolute. And I mean, I in my view, I think we've met that requirement, right? You knowingly did this, right? You conspired with a group of people in a conspiracy to do it, right? To rig the election in many different ways, where the information was allowed to go overseas, where the information was sent to some other place where it shouldn't have gone, right? It was meddled with. You have people stuffing the ballot boxes and other cheats, ballots delivered in the dark of night. So if we met all the requirements, as shown in order below, defendants satisfy the prerequisites for removal. 1, the defendant is a federal officer who did this. Yes, they were all federal officers, right? They all were representing the government. That the charged conduct was carried out for or in relation to the defendant's asserted official authority. Yeah, it was helping them stay in power, right? Helping their races win, the Democrats usually win, right? And certain Republican races that they wanted to keep in. And 3, that the defendant has a colorable federal defense. The Supreme Court has clarified that if a defendant meets these requirements, the right of removal is absolute. So, first, there can be no question that defendants are federal officers. Mr. Brunson's complaint names 129 members of the United States House of Representatives, 94 United States senators, President Biden, Vice President Harris, and former Vice President Mike Pence. Defendants in this action consist entirely of high-level federal executive branch officers and members of Congress. Such office holders cannot be any more federal, quote unquote. Therefore, Section 1442A applies. Secondly, as required by statute, the suit against defendants is, quote, for or relating to acts, quote unquote, under color of federal office, quote unquote. The Supreme Court has characterized this requirement as a, quote, casual connection between the charged conduct and the asserted official authority, quote unquote. Here, Mr. Brunson is suing defendants for actions they took or failed to take in their capacities as federal officers and members of Congress carrying out their respective functions and duties in relation to the 2020 presidential election. Therefore, there is a sufficient connection or association between defendants' alleged conduct and defendants' official federal authority. So that's the second one is correct, right? It has been met. Third, defendants have a colorable federal defense to Mr. Brunson's claims. Quote, a quote, colorable federal defense, quote unquote, is merely an arguable defense, and a court need not determine at the removal stage whether that defense will succeed at trial. In other words, for purposes of federal officer removal. Quote, the question is not whether a defendant's claimed defense is meritorious, but only whether a colorable claim to such a defense has been made, unquote. Defendant's pending motion to dismiss asserts numerous defenses to Mr. Brunson's complaint. These defenses include, but are not limited to, sovereign immunity. Section 1442A1 was intended to protect just such a defense. In fact, the primary purpose for the removal statute is to assure that defenses of official immunity applicable to federal officers are litigated in federal court, quote unquote. Accordingly, defendants' asserted defense of sovereign immunity, among others, satisfies the colorable federal defense requirement. Conclusion. And again, this isn't the Supreme Court's, this is just case text. I just thought it was a good background for us to get into so we can understand what we're talking about, which is this person is suing these 129 representatives from the House, including 94 senators, because they didn't do their duty and they allowed the election process, and some of them, in fact, participated in, right, a conspiracy to rig the election process knowingly, right? Or they knowingly knew about it and did nothing to stop it, right? So there's a couple of different claims being made, right? The biggest one is that you failed your duty, right? You didn't do your due diligence. Your duty as your senator or a congressperson. For these reasons, defendants, for these reasons, defendants satisfy the requirements for removal under Section 1442A. Defendants are federal officers and members of Congress who are being sued for actions performed in their respective positions under color of federal office. Because defendants have colorable federal defenses to Mr. Brunson's claims, including sovereign immunity, defendants' right to removal under 28 U.S.C. Section 1442A is absolute. Therefore, the court recommends that Mr. Brunson motion to remand be denied, which doesn't make sense, right? Or the motion to remand it, which means to another court maybe. So I don't know why. So he's asking that the Supreme Court now look at it, right? Is basically how I'm saying it. Right? He didn't get satisfaction in this court. They didn't read the law correctly, he's saying, right? Let the Supreme Court look it over, and if they tell me that you're right, then I'll walk away, right? That's what he's basically saying. I want another court to look at this because I don't trust this court. You may be compromised, right? Mr. Brunson's additional arguments that remand is required because the federal court is biased against him and the U.S. Attorney's Office has a conflict of interest are unfounded and do not provide a basis for remand. This is footnote 32. The procedural posture of an entirely independent lawsuit filed by Mr. Brunson's brother pending before a different federal judge fails to show that this court is biased against Mr. Brunson in this case. Additionally, the court is not aware of anything in the record or otherwise to support Mr. Brunson's claim of bias. Finally, and significantly, as previously explained, the right to removal in this case is absolute. Manypenny, 451 U.S. at 242. The Supremacy Clause, i.e. Article 6 of the Constitution, means something as any lover of the Constitution would have to acknowledge. Congress enacted Section 1442A to ensure that cases against federal officers were heard in federal court. Because Congress enacted Section 1442, the Supremacy Clause makes it the supreme law of the land. Given Mr. Brunson's desire to protect the Constitution, he cannot reasonably begrudge the supremacy clause's application here. So interesting case. It's way beyond my pay grade in terms of me. I'm not a lawyer, but I'm interested in reading the case out. This is an 18-page case on petition for writ of certiorari that we're going to try to get through. Now, I also noted that there's a 71-page appendix in the back that I got into here that I found. And this is a filed United States Court of Appeals, 10th Circuit, October the 6th, 2022. This is the appendix. So it's a whole other document that's 71 pages that I won't get into now, but I wanted to include it. This is the order and judgment. So I want to get into that later, or not this time because it's just too big. I want to try to tackle this, which is the document that we were talking about, right? Document number 22-380, right? 22-380, which is the Supreme Court case, right? And so here's the case here, 22-380, Supreme Court of the United States. And again, this is on the petition for the writ. And I read this yesterday, the first 2 pages of this, right? But I'll read it again for the record. A serious conflict exists between decisions rendered from this court and lower appeal courts, along with constitutional provisions and statutes, in deciding whether or not the trial has jurisdiction to try the merits of this case. This case uncovers a serious national security breach that is unique and is a first impression, and due to the serious nature of this case, it involves the possible removal of a sitting president and vice president of the United States, along with members of the United States Congress, while deeming them unfit from ever holding office under federal, state, county, or local governments found within the United States of America. And at the same time, the trial court, also has the authority to be validated by this court to authorize the swearing in of the legal and rightful heirs for president and vice president of the United States. So here we go, right? This is talking about, we got to deal with this right now, right? There's not going to be 2 more years of this crap. We want the Supreme Court to look over this case. We feel we've proven the 3 items under 1442 that we need to satisfy to get this ruling and remove these people from office, right? There's a format for this in the Constitution that we're going by, right? We're going through the motions that we're supposed to go through if this was supposed to happen, right? If there is a conspiracy that can be proven, which there now is and can be, of people that sought to rig the 2020, the 2022 election, and possibly earlier elections, right? Possibly every single one for the past 30, 40 years. Right? In addition, there are 2 doctrines that conflict with each other found in this case affecting every court in this country. These doctrines are known as the doctrine of equitable maxim and the doctrine of the object principle of justice. Equitable maxim created by this court, which the lower court used to dismiss this case, sets in direct violation of the object principle of justice, also partially created by this court and supported by other appeal courts and constitutional provisions. These conflicts call for the supervisory power of this court to resolve these conflicts, which has not but should be settled by this court without delay. So these are all the parties to the proceeding, which is Waylon J. Brunson as an individual representing himself as a plaintiff. And there's 388 respondents are a party to this action as defendants, right? So that's all the different people. The 94, was it 94 out of the 100 senators in the government, and then 100 and something, right? People involved in the House, right? Which is a lot. I think it was 194 or 138, right? Was there somewhere where it said it? I don't know. Anyway, so you can see it's all these people, right? Jake Auchincloss, right? Different people. Let's see what we can pick out any names that just pop out at us here. Cori Bush, Tony Cardenas, Ed Case, Clyburn, There's Clyburn, right? And that's why he's not running anymore. He's in this case. He's going to be removed. Joaquin Castro, Liz Cheney. She's done, right? Ed Case. Charlie Chris, who just ran in Florida. Henry Cuellar, who's under investigation by the FBI. All some names that we know, right? Some we don't and some we do. Val Butler Demings, I've heard that name. Anna G. Eshu. Veronica Escobar. Right? Some people we know and some we don't know. Right? Some we know, Al Green, some we don't know. Right? That's okay. This might be the mechanism that we can get all the rot out at once, right? Trey Hollingsworth. Bill Huizenga, Sheila Jackson Lee. There's some names we know. Pramila Jayapal, right? Hakeem S. Jeffries, who's apparently trying to get Pelosi's old spot, but he's one of the defendants in this. I don't know if he's going to make it, right? Mondaire Jones, he was going to be a big guy that was going to move up in the party, right? I heard that name before. Andy Kim, Ron Kind, Adam Kinzinger. That's a name we all know. Raja Krishnamurthy, Ann M. Custer, Darren LaHood, Connor Lamb. So you can see these are a lot of names that we've known and have been there a long time. Barbara Lee. There's more. Zoe Lofgren. Right? There's more. Look at how many people there are on this thing. These are all huge people. Capitalized names, right? Your name's capitalized, right? Been turned into the Jews. Money. Capital is money, right? Gregory Meeks. Grace F. Napolitano, Richard Neal, Dan Newhouse, Marie Newman, Ilhan Omar. There we go. I don't think Ilhan might not be running again. Nancy Pelosi. Here we go. Right? Nancy stepped down, right? Ed Perlmutter. These are big names in the parties, right? In the Democrat Party. Ayanna Pressley. Right? These are huge names. Jamie Raskin. Remember him from when they were trying to frame Trump, right? Chip Roy. C.A. Dutch Rupersberger, Bobby L. Rush, Tim Ryan, Linda T. Sanchez, Adam Schiff. Big names, right? All the big names that we were watching all these years, doing all the dirt, right? Adam Smith, Christopher H. Smith, Darren Soto. More. The names go on and on and on, right? Hundreds of people that did this. This is a massive conspiracy, right? Rashida Tlaib. So we got, what, 2 of the squad members already on this. Where's the rest? AOC in there? Fred Upton, Juan Vargas. Nydia Velasquez, another Democrat. Debbie Wasserman Schultz, another huge Democrat. Maxine Waters, another huge Democrat. All right? The following persons named are for their capacities as U.S. Senators now. Tammy Baldwin, John Barrasso, Michael F. Bennett, Marsha Blackburn, Richard Blumenthal, Roy Blunt, Cory A. Booker, John Boozman, Mike Braun, Sherrod Brown, Richard Burr, Maria Cantwell, Shelley Capito, Benjamin L. Cardin, Thomas R. Carper, Robert P. Casey Jr., Bill Cassidy, Susan M. Collins, Christopher A. Coons, John Cornyn, Catherine Cortez Masto, Tom Cotton, Kevin Kramer, Mike Crapo, Steve Daines, Tammy Duckworth, Richard J. Durbin, Joni Ernst, Dianne Feinstein. These are the huge big names. Deb Fisher, Kirsten E. Gillibrand from New York Senator, Lindsey Graham, Chuck Grassley, Bill Hagerty, Maggie Hassan, Martin Heinrich, John Hickenlooper, Mazie Hirono, John Hovind, James Inhofe, Ron Johnson, Tim Kaine, Mark Kelly, Angus S. King Jr., Amy Klobuchar, James Lankford, Patrick Leahy, Mike Lee, Ben Lujan, Cynthia M. Loomis, Joe Manchin III, Edward J. Markey, Mitch McConnell, Cocaine Mitch, Robert Menendez, Jeff Merkley, Jerry Moran, Lisa Murkowski, Christopher Murphy, Patty Murray, John Ossoff, Alex Padilla, Rand Paul. Wow, Rand Paul's in this. Gary C. Peters, Rob Portman, Jack Reed, James E. Risch, Mitt Romney, Jackie Rosen, Mike Rounds, Marco Rubio. So there's some Republicans and there's both parties in this, right? Bernard Sanders, Bernie Sanders, Ben Sass, Brian Schatz, Charles F. Schumer. There's Charles. Rick Scott, Tim Scott, Gene Shaheen, Richard C. Shelby, Kirsten Sinema, Tina Smith, Debbie Stabenow, Dan Sullivan, John Tester, John Thune, Tom Tillis, Patrick Toomey, Holland Van, Mark R. Warner, Raphael G. Warnock. So Warnock, who's running against in Georgia, right? Running against Herschel Walker. Elizabeth Warren, Sheldon Whitehouse, Roger G. Wicker, Ron Wyden, Todd Young, Joseph Robinette Biden Jr. in his capacity of President of the United States, Michael Richard Pence in his capacity as former Vice President of the United States, and Kamala Harris in her capacity as Vice President of the United States, and John and Jane Doe's 1 through 100, who you don't even know who they are. Here's the appendix. List of proceedings. Waylon J. Brunson versus Alma S. Adams. Jurisdiction is found under 28 U.S.C.A. Section 1257A. Supreme Court Rule 14F provisions. Amendment 1 of the Constitution of the United States, quote, Congress shall make no law respecting an establishment of religion or prohibiting the right of the people peaceably to assemble and to petition the government for a redress of grievances, quote unquote. Article 6 of the Constitution, quote, this Constitution and the laws of the United States shall be made pursuance thereof shall be the supreme law of the land, and the judges in every state shall be bound thereby, unquote. 2. 14th Amendment to the Constitution of the United States, quote unquote. Quote, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws, quote unquote. Section 3, quote, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or a judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may by a vote of 2/3 of each house remove such disability, quote unquote. Fifth Amendment of the United States Constitution. Quote, no person shall be deprived of life, liberty, or property without due process of law, quote unquote. Ninth Amendment of the Constitution of the United States, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, quote unquote. Article 1, Section 7 of the Constitution of Utah, quote, no person shall be deprived of life, liberty, or property without due process of law, quote unquote. Article 1, Section 2 of the Constitution of Utah, quote, all courts shall be open, which shall be administered without denial or unnecessary delay, and no person shall be barred from prosecuting or defending before any tribunal in the state by himself or counsel any civil case to which he is a party, quote unquote. 3. Statement of the case. This action is against 388 federal officers in their official capacities, which include President Joseph Robinette Biden, Jr., Vice President Kamala Harris, Speaker of the House Nancy Pelosi, and former Vice President Michael Richard Pence, respondents. All the respondents have taken the required oath to support and defend the Constitution of the United States of America against all enemies, foreign and domestic, and as such they are liable for consequences when they violate the oath of office. Respondents were properly warned and were requested to make an investigation into a highly covert, swift, and powerful enemy, as stated below, seeking to destroy the Constitution in the United States. Respondents purposely thwarted all efforts to investigate this, whereupon this enemy was not checked or investigated. Therefore, the respondents adhered to this enemy. Because of respondents' intentional refusal to investigate this enemy, Petitioner Raylan J. Brunson, quote unquote, brought this action against respondents because he was seriously personally damaged and violated by this action of respondents. And consequently, this action unilaterally violated the rights of every citizen in the United States, and perhaps the rights of every person living in all courts of law. On January the 6th, 2021, the 117th Congress held a proceeding and debate in Washington, D.C., quote-unquote proceeding. This proceeding was for the purpose of counting votes under the 2020 presidential election for the President and Vice President of the United States under Amendment 12. During this proceeding, over 100 members of U.S. Congress claimed factual evidence that the said election was rigged. The refusal of the respondents to investigate this congressional claim, the enemy, is an act of treason and fraud by respondents. A successfully rigged election has the same end result as an act of war, to place into power whom the victor wants, which in this case is Biden, who, if not stopped immediately, will continue to destroy the fundamental freedoms of Brunson and all U.S. citizens and courts of law. Due to the fact this case represents a national security breach on an unprecedented level, like never before seen, seriously damaging and violating Brunson, and coincidentally affects every citizen of the USA and courts of law. Therefore, Brunson moves this court to grant this petition, or in the alternative, without continuing further, order the trial court to grant Brunson's complaint in its fullest. Brunson's complaint is the mechanism that can immediately remove the respondents from office without leaving this country vulnerable without a president and vice president. So in other words, people have moved against this country, right? They've harmed us by rigging the election and giving comfort to those who were doing it without investigating it when they were asked to investigate it, right? Despite the grave importance of this case, the trial court granted respondents' motion to dismiss motion by stating, quote, "It is ordered and adjudged that plaintiff Raylan Brunson's action is dismissed without prejudice," quote unquote. Quote unquote order. This order followed the trial court's order to adopt its report and recommendation that Brunson did not get until close to the beginning of October 2022, thus prejudicing Brunson from timely filing any objections, and the order did not properly address Brunson's opposition to the motion. Brunson's opposition clearly shows that Brunson has standing. So you slow rolled this response so that by the time he got it, he couldn't even respond really properly, right? So much time had gone by and he'd already rigged the election and it had, a long time back now. Per Brunson's opening brief and as outlined in Brunson's said opposition, both not properly addressed by the lower courts, Brunson's has standing in the trial court as full proper jurisdiction to rule on the merits of this case based upon the following factors. A, the case of American Bush versus City of South Salt Lake, 2006 UT 40 140P 3D 1235, clearly states that the Constitution of the United States, along with state constitutions, do not grant rights to the people. These instruments measure the power of the rulers, but they do not measure the rights of the governed, and they are not the fountain of law, nor the origin of the people's rights. But they have been put in place to protect their rights. Therefore, the statutes and case law cited by respondents claiming immunity from Brunson's claims in this instance are unconstitutional, and this court needs to rule in that manner. B, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, quote unquote. Therefore, the purpose of the Constitution was written to protect our self-evident rights. The Constitution cannot be construed by any means by any legislative, judicial, and executive bodies, by any court of law to deny or disparage our rights. This is the supreme law of the land. Interesting, law of the land instead of law of the high seas, right? Which is what we're actually under. It's supposed to be law of the land, right? Quote, this Constitution and the laws of the United States, which shall be made pursuance thereof, shall be the supreme law of the land. And the judges in every state shall be bound thereby, quote unquote, Article 6 of the Constitution. C, the The First Amendment of the Constitution states that Congress shall make no law prohibiting the right of the people to petition the government for a redress of grievances. D, quote, our courts have consistently held that fraud vitiates whatever it touches. Morris v. House, 32 Texas, 492, 1870, Estate of Stonecipher versus State of Butts, 591 SW2D 806, and, quote unquote, it is a stern but just maxim of law that fraud vitiates everything into which it enters. Quote unquote, Veteran Service Club versus Sweeney, 252 SW2D 2527, KY 1952, Kentucky 1952, Radio Shack Corp versus ComSmart Inc. 222 SW3D 256. Vitiate, to impair or make void, to destroy or annul, either completely or partially. Excuse me. The force and effect of an act or instrument, quote unquote, Western Encyclopedia of American Law, Edition 2. E, due to the uniqueness of this case, the trial court does have proper authority to remove the respondents from their offices under 18 U.S. Code Section 2381, which states, quote, whoever owing allegiance to the United States levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death, or shall be imprisoned not less than 5 years, and fined under this title, but not less than $10,000, and shall be incapable of holding any office under the United States, quote unquote. A court adjudicating that the respondents who have taken the oath of office to be incapable of holding their offices or who have adhered to a domestic enemy means nothing without such removal of office. Under the stated factors, Brunson has an unfettered right to sue the respondents under the serious nature of his claim. No legislation can measure Brunson's right to sue the respondents. Furthermore, Brunson's allegations against respondents adhering to a domestic enemy and committing acts of fraud are not protected by any kind of legislation of jurisdictional immunity. Essentially, acts of Congress cannot protect fraud, nor protect the violation of the oath or that give aid and comfort to enemies of the United States Constitution or America as alleged in Brunson's complaint against the respondents. These are facts that cannot be overcome. Therefore, Brunson found no need to include in this petition a copy of respondents' opposition to Brunson's opening brief or any of their arguments. Right. In other words, you've committed treason. Nevertheless, Brunson's opening brief does touch upon respondents' immunity arguments and shows how respondents do not, nor can they overcome Brunson's arguments as stated herein. It is an uncontestable fact that the respondents committed fraud and treason, breaching our national security, as factually alleged in Brunson's complaint, thus adhering to a domestic enemy that continues to breach our national security at an alarming rate on a daily basis. This national security breach is having the same end result as an act of war, to place into power whom the respondents want, which is Biden. Brunson moves this court with his powers to order the trial court of this case to immediately grant to Brunson the damages he seeks in his complaint. This is necessary to immediately secure our national security without any further delay. Turning now to the doctrine of equitable maxim created by this court. This doctrine stands in direct conflict of the doctrine of the object principle of justice. The doctrine of the object principle of justice is couched by the supreme law of the land and sets in motion to provide our court system to be the most just, limited, highly effective, and easy to understand, and infuses our court system to be the most highly respected and dearly admired court system greater than the world has ever seen. The doctrine of equitable maxim kills this, and had the trial court been guided by the object principle of justice, this appeal would not be necessary. In addition, the doctrine of the object principle of justice stops the precarious nature of our courts. Their jobs would be much easier with less stress, and parties in court would have a strong sense on how the court is going to rule, thus promoting settlements to a high degree, and as such, lawsuits and appeals would be greatly reduced. This is an absolute fact. Jurisprudence requires this court to revoke the doctrine of equitable maxim that is created and to instill the doctrine of the object principle of justice more thoroughly throughout the entire court system in America. The doctrines of equitable maxim and the object principle of justice are fully explained in a petition before this court under docket number 18-1147. To avoid being repetitious, Brunson herein incorporates the argument found therein as though fully stated herein, and moves this court to address the question either under this petition or docket number 18-1147. Reasons for granting this petition. Brunson's complaint alleges fraud, violations of the oath of office, and touches on acts of treason committed by the respondents. These serious offenses need to be addressed immediately with the least amount of technical nuances of the law and legal procedures, because these offenses are flowing continually against Brunson's liberties and life, and consequently is a continual national security breach. Voting is the greatest power an individual can exercise in a republic. It is Brunson's personal voice and the way he can protect his personal constitutional protected rights in the U.S. Constitution. See paragraph 71 of the complaint. When the allegations of a rigged election came forward, the respondents had a duty under law to investigate it or be removed from office. An honest and fair election can only be supported by legal votes. This is sacred. It is the basis of our U.S. Republican form of government protected by the U.S. Constitution. The efforts made as stated in the complaint that avoided an investigation of how Biden won the election is an act of treason and an act of levying war against the United States Constitution, which violated Brunson's unfettered right to vote in an honest and fair election, and as such it wrongfully invalidated his vote. As a national security interest, Brunson moves this court to be swift by going beyond granting this petition. It should order the lower court to grant Brunson's complaint to avoid any further delay. Conclusion. This petition is set forth in the interest of justice in protecting Brunson's right to the petition for a redress of grievances against the respondents and ensuring his right of due process against the encroachment of the doctrine of equitable maxim, and charging the respondents who failed to investigate the allegations of a rigged election by having them removed from office without further delay. Dated October the 13th, 2022. Respectfully submitted, Raylan J. Brunson. I'm not going to say the address here, Ogden, Utah. Petitioner pro se, and that's the end of the document. And there's also a 71-page annex part, or another part of the appendix part, that I'm going to include. I won't read through it. So that was a super interesting document, because it's basically the complaint is very simple, right? You allowed the election to be rigged, and you didn't do your constitutional duty to protect the Constitution of the United States, to protect the voting process. Therefore, you should be removed under office and under these different sections that are put in place just for these types of things, right? When there's a conspiracy, right, of people that do not act and do their job properly and allow our election process to be rigged. So it's a super fascinating document. I'm glad I got to read it out loud to everybody so that we can get a better idea of the document itself. And again, if you weren't listening, this is case number 22-380 in the Supreme Court of the United States. Raylan J. Brunson, petitioner, versus Alma S. Adams et al., respondent. And the respondents and the defendants in this case are 94 of these people in the Senate whose names I read, and 100 some odd people in the House of Representatives. So keep an eye on those names. I'm glad I got to read this into the record. Again, this is Supreme Court case number 22-380, Raylan J. Brunson, petitioner versus Alma S. Adams. Thank you for allowing me to read this to you. This is your friend Ash from WATN News, signing off for now.
So, okay, guys, I'll go back. I had that on full screen. Let me go back and put him. Let me see if he's got that document. He does. So, I mean, he's got a couple things here. Oh, that's the appendix. And this was the PDF. I hope it fits in the chat. But I'll add this link to the description, right? So if you want to go over it, yeah, it didn't all fit. But if you want to go over that, it'll be in the description. So, you know, that's the petition and so, but that is coming to the Supreme Court. And win, lose, or draw, these guys had the wit enough to step outside the box, right? So where everybody else was saying, oh, we had all this evidence, this didn't happen, that didn't happen. We've seen the same thing happen in Georgia, same thing happen in Arizona. There's in front of Congress or somebody, the actual programmer that was approached to make a program in the year 2000 to, no matter what the vote is, to do a 51-49. That program just switched it like that. Maybe it was fractional voting or and it's my belief that even before that program, there were still some shenanigans in other countries, because what does the CIA do? Right? They operate in other countries. So, sorry, I'm it moved along with the times. So we've become more digital. We've become, you know, it's no worse than Twitter banning certain things, right? That's a digital war. That's an information war. You only have to accept the narrative. You can't decide for yourself. You just have to believe what we say. So anything we don't believe or anything we don't want you to believe, well, we're just going to take out. So, you know, and by the way, hey, fact checkers, I got one for you. So, CNN, MSM, y'all said, of course Joe didn't want his son showing his junk. Let me ask you guys something. Have you ever been able to post a nude picture on YouTube, Twitter, Facebook, and let that shit stay up for 8 days? No, they're going to take you down within 24 hours. The only thing I ever seen was a crop picture of his hairy little chest with a crack pipe in his mouth and a blurred out picture of something that looked like a 10-year-old child. Okay? And no one was naked. It will not be able to stay up on any of the main platforms. Nope, sure won't. Fact check that, won't ya? In any event. So, yes, Watchmen, I seen that. So, and you know, it's funny, because my whole thing about abortion was, how can you take the life of an innocent child, but yet you lock somebody up that wants to commit suicide? They locked up Kevorkian, right? And those were people that had like Addison's and like really bad diseases. They were in a lot of pain. And that man got locked up in the 80s, the 90s. Now they want a death panel. And if you're mentally ill, yep, oh, no need to slit your wrist. You might fail. Let us hook you up. Oh, Watchmen, it's an atrocity. I didn't like it. You know, you show me somebody that ends up at the bottom of the barrel and I think you're going to find the newest Christian, because until you go way down, until you're really, really confused, I don't think you find God, because you never got there. Yes, there are bad circumstances. Yes, things happen. But, when you hit Skid Row because of drugs, when you can't get your drugs, you can't get your fix, and you're suffering, there's only one more place to ask for help, and that's to call out for Jesus, right? It takes a little work when you're that far down and you've had to do just awful things. Jesus gives you a little, then you show, how do I want to say it? You show initiative. Maybe you hit church once a week. Maybe so you can eat, you go do something good like work at the food bank. Then you get a meal. So then things don't look so bad, right? But I think when COVID started, I think there was a whole new explosion of people that found Christ. They were miserable. They were locked up in their homes. They couldn't be near their family. Family members passed away. They couldn't hold their hand. And they cried out for help. And you know what? I think they cried out to Jesus. And that's a good thing. Not that people died, get you? But, okay. But the one person that is so desperate and is so down on their luck, and they have no other way to go. Sorry, I got a dry tickle. Sometimes they look up to the sky and they say, God, are you out there? Jesus? It's kind of a give and take. You give a little faith and you get a little push in the right direction. And I'm a firm believer in that. So if they think that COVID literally broke us all apart, they closed down our churches. We still had the telephone. We still had ways to communicate. Yes, disciple. But the Department of Transportation cells were traded on the market. Yes. And actually, look into the Department of Transportation and your birth certificate. I'm going to have a little bit of digging to do. I will bring up a show. I do a little diving. I got oh sorry, I had to get my water. The holidays are here, and with Thanksgiving, and we had some stuff, and of course, I'm doing my business. So I had gotten half-ounce trials. I got all these new great designer scents and other scents like peach and really cool stuff. And I've been trying to make soap for 3 weeks, and the rest of the scents came in on Saturday, and I still haven't been able to make soap. And of course, I got friends, and my friends are on the East Coast, so 1 o'clock their time is 10 o'clock my time. And I really do. I try to give an ear to listen, right? But for at least a week, I've been saying, please don't call me till 9 o'clock your time, because it's 6 o'clock. And we eat early dinner here. We eat by 3. and we're done. And at some point, and I don't eat breakfast, usually, maybe Sunday. So literally, yeah, I got some peach. I love peach tea. In any event, so my one friend, he drinks a little. And I don't know, some people, want to say different things about me. And, you know, I'm drinking bottled water and I'm going to have a big old cream cheese and milk. So we went out today in public. So I got some colloidal silver. I'm going to spray some down my throat. I don't think it reached 30 ppm yet. So some hot tea. You're right, Watchman. Some hot peach tea with honey. And I think, no, the jars I got are with the dropper. Oh, Watchman, let me tell you something. So I don't know if I have the seeds here, but I'm going to grow loofah. Like, I always thought loofah came from the sea. I thought it was like, some kind of sponge sea creature. It's actually a plant. You got to grow it up along a fence, and you got to pick it, wait for it to dry out. You can hear the seeds. Then you got to soak it and peel it. But then you can cut them into like little round things. You could tie a little soap around it, and that's your soap on a rope with loofah, right? I've seen some people like they'll do peach on one side. I don't even know how they do it, but it's absolutely amazing. Oh, no, drop. It's not your fault. Oh, okay. So hold on. I got to tell you about these biscuit, egg, and cheese biscuits, right? It was two biscuits with a huge thing of sausage, some egg, and cheese. Literally, it was so huge. I ate half of it and I was crashed for 2 hours. So, Drop will tell you when I eat, I just crash. So, like, I can nibble, but I can't really get full because if I get full, I crash. So, eating gives me a nap. That's why I like my bagel, cream cheese, and milk at night because my tummy's full and then I sleep throughout the night. That's just the way that works. But yeah, hot tea is a good idea. We had to go out today. When we go into town, it's always 4 to 6 hours. So we have all the stores we want to stop out. There's one store where you can get discounted meats, and the other store we found over 2 pounds of lean ground meat for six something, right? So I got four. I'm like, drop, man, that's a really good price. And we, I don't think we had been out in town for 2, 3 weeks. Maybe we still can't get up to Walmart. I got my list for there. I need more tomato sauce, we make a list, so we always stock up with enough stuff um, that we're not going to be without. So once the snow starts flying, I ain't going nowhere. He can say, "Hey, I'll drive you." I'm gonna be like, "No, thanks. Nope." Yeah, well, hey, Watchman, I cooked twice this week. Actually, 3 meals. I did cheeseburgers. I did that one of those great big things of ground meat. I made Salisbury steaks, and Tuesday we had steak, mashed potatoes, and gravy, and Brussels sprouts. So um, yeah, we still got leftovers. So we got like a lot of stuff for salad. So maybe tomorrow, maybe I'll roll up some, chicken, uh, sliced chicken breast. Maybe we'll do grilled chicken over salad or something. Yeah, Watchmen. I mean, we prep, and there's no way that I mean, we got our own deal, you know, so I help where I can. Drop does his stuff, you know what I mean? So I'm not very particular. Ground meat is ground meat. I mean, for the most part, you know, what do you do with ground meat? You make hamburger, yeah, a meatloaf, maybe some tacos or burritos, and you can drain any fat, rinse the fat, and you're okay. Oh, did you really? Yeah, but you know, I've had the worst freaking ground meat that you could think of, and as long as you mix it with something, it's a meal. Um, but no, it was very lean ground meat, and I think each package was just a little over $6. And there's this one store we can hit. It's called Mitchell's, and Mitchell's. A lot of times on the very last day, the sell by date. I mean, I've gotten extra lean ground meat for like $1.49. So, you know, it probably wasn't even a pound, but then they take $3 off. So when we go into town, we always shop for that. You know, and we'll hit at least 3 grocery stores, and I grab the list. Drop will tell you. I'll grab the list. I don't want bagels. I go over to the bagel section. What do they have on sale? They want $4.99 or $5.99 for 5 or 6 bagels. So unless they're on sale for $3.49, I don't touch them. So you know, we have our little list. We have our Walmart list. So oh no, Watchmen, I won't buy it in a tube. Yeah, no, I want to look at that meat. Yeah. So, you know, these smaller stores here, there's like a Safeway, a Mitchell's, Yolks, and you see all the meat. But like I said, you know, we know where to go to check out the discount. I remember there was a time I think Walmart was charging about $15 for like 4 chicken breasts. That was it. There was nothing special about them. They were chicken breasts. And I'd look at it and I'd shake my head and be like, I ain't paying that. I think a lot of people couldn't afford it, so they had to lower the price, or they were going to end up with a lot of donations for the food banks, which isn't a bad thing. But I think at a certain price, you know, unless you're absolutely destitute, I think you're going to walk away. I mean, like, I really wanted a DiGiorno pizza. $8.99. We're talking about a pizza that used to be $5.99. I looked it up. I'm like, nope. The most I was willing to pay was $6.99. Now we make our own pizza, and and that's what he said. He said we make our own pizza, and I'm like, yeah, but it's DiGiorno, right? Nope. I was not willing to pay $9 for a frozen pizza. Ain't happening. So it's not that we're gonna starve, right? Like, we put back food when something's on sale. We buy it. We put it back. So we're not like absolutely destitute. So it is what it is. You just got to find the deals as you get them. I mean, if you're going to go out shopping, stop at a few stores. And then I have, Drop will tell you, I got prices memorized in my head. You know, it's like, I don't know, 2, 3 weeks ago, we went out and he's like, yeah, I need butter. Okay, so he has his list. I got, you know, my stuff. And we passed up a deal in one store, and the 2 other stores we went to, it was like $4.99, $5.99. I said, see, that first store, it was $2.99. That was a good deal. So today we found butter for $2.99. We didn't even look around. We said we're getting it. TUBERVILLE. Yeah, no, we make it from the dough and the yeast, and I'm gonna Drop does his pizza. I do mine. Mine is usually 4 pizza doughs. You just cut it up and it's real fluffy. Yeah, right, Watchman? So, you gotta hit them very early in the morning because they do all the discounted meat very early in the morning. And that's what we do. So, it's the last day sell by date. It doesn't mean it's bad, but it means when you get it home, you gotta put it right in the freezer, take it down and cook it that day, whatever day you're gonna cook it. And Watchman, that's coming December 13th. That EO was signed and it goes into effect December 13th. Now, the feds already have a digital form of currency they're trying. So, I don't know what's going to happen the 13th, but okay, so I don't trade in the markets, right? But I watch this guy, beginner trading. And, so I wake up 4 or 5 in the morning, I turn this guy on, and I'm absolutely watching the markets. And one of the things I said today, and I talked to Drop last night, and I said, if they go digital, it's going to crush the markets. I'm betting. Now, I don't know. I don't know anything about the markets, but I'm betting that a lot of these people that are doing some shady things for money, drugs, trafficking, whatever, they got a lot of cash. They might walk up to an establishment, that a brokerage firm, and say, yeah, I want to buy in the stocks. So that money gets hidden. It's not in a bank. It's safe. However, when they start investing it, then they're getting the money back, and they can account for whatever they take off the market that they made, right? But when it goes digital, I think the stock market is a laundering service. It's, just like we gave all that money to Ukraine. Yeah, that's not going all to them. I want to see an audit. I want to see the equipment. I want to see it blown up. I want to see the empty shells, and I want to know where that money went. And look, don't even tell me money to the border, because we ain't spending it on our border. Why is Ukraine's border? What? Just because Russia's next door? Please. Yeah. Watchman, I'm 4'11". I went up to one of those automated things, which always freaked me out. But they can only get a picture of my forehead, so it's set at a certain height. When you're really, really short, they can't. I mean, I do. I've walked through the stores. I've seen the things, and yes, it's digital e-commerce for selling us on the market. And it was just like, I can't say the proper name for the tests, that they used in the last 2 years. But when you look up how they do DNA tests, that's the exact test. Those were never, they said they were never created to, how did they put it? It was never created to diagnose a disease. So when you look at that, go ahead, just, get on Google or something, and just Google in, how do they do a DNA test? They're going to tell you how they scrape it from your nose. And then back in the 2000, I think they used to swab your mouth. But a really good, so they're selling all that, right? Facebook sold you know, our thoughts, our pictures. YouTube did it. Um, Everyone's doing it, and why? You have to ask yourself, why would anyone want to buy that? Well, if I got your DNA and you come from a certain bloodline, or just say you're a certain blood type, let's just say you're A blood type. A blood type might be a descendant from, I don't know, somebody in history. Maybe they want to knock you out. Maybe. Okay, drop. Yeah, monkey is. Oh, monkey's behind me. But in any event, and like a lot of people are like, well, what would they look? They started the whole DNA gathering when they ended up doing 21 and Me or that family tree thing, okay? They started gathering it then, and honestly, maybe they put a name to the DNA. I don't know. Maybe they have the whole family tree, and they can find out. Oh, I don't know, guys. I don't understand it, but my DNA is Mayan. They do, Watchmen. Like I said, when I walk through the store, they have these little like TVs. I can see me walking. Um, and they do. I mean, I think it's crazy. You have to be a flippin' weirdo to want to see people. I get it. So we were all told it was security. Do you know I got agoraphobic and couldn't go into Walmart for the longest time? Because I was like, man, sometimes I just throw on a baseball cap and a pair of pants and a shirt, and I'm like, okay, I gotta do this. So I mean, if I'm gonna be on camera and somebody wants to, you know, at least I want to look my best. No way, Watchmen. See, all that stuff's coming. They've got us. It's like a spider web. And if they do the digital currency, and I had an issue with my bank card, and I was trying to buy something from Walmart online, so it kicked me out. I'm like, I know the money's there. So my debit card, I said, okay, let me not use the debit. Let me use the credit. It still kicked me out, kicked me out, kicked me out. And I was like, what the holy heck? So I don't know. I literally had to call up my bank and go, what's up with this? Oh, we thought there was fraud. I said, so you retch up my account for days? So meanwhile, I'm trying to buy from a lady that has oils, and that payment got held up for 72 hours. I'm like, oh no, this ain't right. This is not right. So, you know, if they figure out BB is Murphy's Law, eventually they will. You know, I figured, not that I'm ashamed of my name, but Murphy, right? So, you know, I sign into things. They're like, hello, Phoebe. So I'm just hoping that, you know, I just want to be left alone. I don't want to be a part of their system. And, you know, Jesus turned the tables for the money changers. And this is all about these people with this social disease of climate change. And, you know, I don't even think it's a climate change sickness. I think it's about the money. When we were all masked up and we were home, guess what? They went up in the atmosphere. They found out that 27% reduction in the CO2 and all the pollution. So you think they really want us to go without a mask? But the more implications they can put in, whether it's wear a mask or do whatever, Then one of their friends are going to make the masks and make the money, and so it all comes down to the Benjamins. It's all about them. So but just you gotta pray for eyes to see and ears to hear, and you gotta use your own discernment, right? And that's a good thing, because the more you know, the more that you can avoid stuff that might be coming down the pike. Hey, you're not gonna tell me, hey, you're starving. I got a warmed Oh, you're cold and you're hungry. Well, come with me. I got a warm station and there's food there. Uh, Sounds like a FEMA camp to me. Yeah. These people, what was it, back in August? What was it, somewhere in Europe, Germany? They had cooling stations. Cooling stations for humans, guys. And guess what? I don't even think anyone has to do anything to a certain state of the grid. I think all they have to do is hit the switch, and they can make it up as they go along. Oh, yeah, some lone gunman fired off 2 shots, just happened to hit the exact thing that needed to be, and they still can't find the guy. What? I would think there would be so much security around our grids. But I'm kind of thinking, Watchmen, those people, there were more people back then that knew how to grow a garden and they knew how to can. A lot of potato soup, unlike today, only about 1% of the people, at least here in America, I don't know if it's worldwide, know how to grow a garden, right? You got 99% of the people. Now, granted, I love going to the grocery store. I love to get some frozen carrots. I love to get that stuff. However, we didn't grow carrots this year. So people are not accustomed to doing the work. They're working 2 jobs to pay a credit card. They ain't got time for a garden. They live in an apartment. They ain't got the room for the garden. You tell me how 2030 the smart cities is going to work for anyone. They're all going to be on the teat of the government, and step out of line. Crime thought, yeah. You get no food, like the soup Nazis. Hi, Trinidad. So, these are all things, you can find the deals. Gosh, that was over 2 pounds of ground meat for like $6. And that would feed 3 people 2 meals, right? So you know where I'm going. Oh, $3 for the main meal. Yeah. Either some baked rice or, we actually, last time we went out, I found Idaho loaded potatoes. They had them discounted at 78 cents. I'm like, oh, heck yeah. So, in any event, just try to put some stuff away. And if you grew a garden, hopefully you got some seeds. You can plant a little extra, take care of some people in the neighborhood. That's what we're going to try to do. And we had lots of herbs, yarrow, and everything that we literally got the seeds from the yarrow. Mullein, we got the seeds for. We got the leaves. We have the indoor grow room and the outdoor. And chicken's not laying so many eggs now, guys. They're like really dormant. So we just do a little bit at a time. But if we're going to go spend $150, we're gonna shop around for money, and oh, and the Dollar General here, they have cheese raviolis, a small bag, probably enough to feed a family of 3. Even if you had to get 2 bags, $1.25 a bag. They have vegetables. And I look, Drop is so patient, let me tell you. I'd be like, yeah, I want to go here. I know what's where. Oh, yeah. Oh, hold on. Let me grab the brochure. And I'm like, not a good price, not a good price, bad price. Chips are unreasonable. I don't even think you could touch a bag of potato chips for less than $4. And I'm like, nope, I ain't spending $4. You can keep them. And yes, Watchman, you're correct. It is feast or famine, but if I can, right? So if our freezer overfloweth, then I'll just make a meal and can it. Even like the turkey soup, I think it was 6 quarts. We all ate as much turkey soup as it was actually a double batch. We ate as much as we could. And then we were like, okay, yeah, we're done with this. And I'm like, okay, let me can it. So I canned 6 quarts of that. And probably, I'm guessing if we opened 2 quarts, it would feed the 3 of us, and we'd have, a little, like, small little cup for lunch. So, and then I made American goulash, and I love it. I ended up making a double batch and a whole case of points. And it's not like we don't use it. It's like, hey, if I want American goulash, I'd go over, I'd pick up. But canning is going to be a really smart thing for everyone to learn. You grow all the vegetables you want in the summer, but how are you going to preserve it? And I know usually by July there's no canning supplies, so you gotta get those jars like May, June, even before you plant. Then you gotta learn how to can. I mean, come on, the people did it in the 1800s. They didn't have these luxurious canning baths or they didn't have any of that. They did what I call rebel canning. Oh, yeah, you have to be a little comfortable. What's all those millions for? You can't take it with you when you go. Be a little comfortable, eat what you want. You got a little extra, you give it. Any of them. So, I mean, and if y'all can do something good for the community, I don't know, find your local shelter. I heard that animals are literally getting turned in because people don't have the money to feed them, or they don't have the money. Um, they don't have the money to take them to the vet. So I don't know, if you got an extra $20, grab a thing of dog food, cat food, drop it off at um, your local shelter, right? They're just overrun, and it's a shame. I mean, I'd never give up my pet, because guess where I stayed for 8 months? In my car to keep my parrot that I had for 23 years, right? I had a place to go. I sure did. It cost me more to live in a car to stay with my parent and keep her warm than it would have anywhere. Yes, yes, sure is. Disciple, the Messiah, he's everywhere. So's Watchman. But I mean, anything, do something. If you're doing well with money, I mean, drop off a couple bags of potatoes to your local food bank. Okay, you're thinking it's only 2 bags. Well, trust me, if 2 bags is all they have, they'll break out some Ziploc baggies and they'll give 2 bags to every person. Oh no, that's not him. No. No, this one is the real deal. He's been around forever. Well, they could Trinidad, but this guy's sometimes if there's no space and it's all together, or they might put a little symbol. They do. People change it, and what happens? Why people do that is, I don't know. You're being stalked online, so most people will think, "Oh, that's a bad person," but it's not the same person. You know about the stalkers, Trin. Yeah, and that's true. That's true. But anyway, guys, it's been 2 hours and 35 minutes. I'll play some music. Well, I'm going to finish the one song. Because don't you know, they're going to give me a copyright no matter what. So I'm going to play the real deal. Because that's just the way I am, right? So, okay, if it ever loads. Oh, gotta wait. So anyway, the newer computer came in, so we're charging it up, and then I gotta sign into everything, and I will be so happy. This has been a good laptop. I've had it almost 5 years. That noise you hear in the background is probably the fan. My cats have flipped it. They have torn some buttons off the keyboard. It almost looks like there's an eruption on one side. So anyway, hopefully I'll have the new laptop up and running. So here's some music so y'all can say goodnight.
New Orleans to where that falling train well, there is a house in New Orleans they call the Rising Sun, and it's been the ruin of many a poor boy. In God, I know I'm one. Riders on the storm. Riders on the storm. Into this house we're born. Into this world we're thrown. like a dog without a bone, an actor out of bone. Riders on the storm.
Okay, everybody. Good night. God bless. And Messiah, definitely email me. Like I said, my computer, the old one, is just so messed up. I can't even get into my email, but I am getting stuff on my phone. So, of course, I have to turn my phone off because I got a lot of friends on the East Coast. You know, when it's 3 o'clock their time, it's noon here, and I got stuff to do. So much love, everybody. And I will definitely put that show together about maritime law, the gold fringe, how when you see a judge, you know, especially a federal judge, and how everything is linked to the transportation department, how they're, your birth certificate, they're trading you on the market. And I guess they say, okay, this person, maybe that's what the DNA's for. This person's life expectancy is 90 years old. They will work 60 years of their life, right? I don't know, but you know it's got to be about money. But God bless everyone. Love you. Good night.